Section 274 sets out heightened substantiation requirements for tax deductions for certain types of expenses. This includes expenses under Sections 162 or 212 for travel expenses, for gifts, or with respect to listed property. According to Section 274, these expenses are only allowable if the taxpayer produces various records or evidence. The Cohen rule that allows estimates does not apply to expenses that are limited by Section 274. Because the Cohen rule does not apply, IRS auditors often propose to disallow these expenses. The reason why these expenses are disallowed may be based on an unattainable record-keeping standard. Technology has allowed activities to be tracked with precision in a way that they could not be tracked just a few decades ago. While this may sound like a justification for a higher substantiation requirement, it is a justification for just the opposite. It is against this information tracking overload and burden that taxpayers often do not keep records. Mileage logs are an example. They are an inconvenience that adds to the information creating standard that we are expected to live with today. There are exceptions, but they are few and far in between. For example, these rules do not apply to cases where records were kept and lost due to natural disasters, fires, etc. As another example, expenses for qualified non-personal use vehicles are not subject to these rules. According to Section 274, a qualified non-personal use vehicle is any vehicle which, by reason of its nature, is not likely to be used more than a small amount for personal purposes. The regulation goes on to provide a long list of types of vehicles that fit this bill. This includes clearly marked police, fire and public safety officer vehicles, ambulances or hearses, cargo and delivery vehicles, bucket trucks, cement mixers, and the likes. This list is not an exhaustive list. There are other vehicles that qualify, and other types of expenses that are also exempt from these rules.